Good morning, everyone. Thank you all for joining us today on Gen 2's panel on the SEC Fund Advisor Rules. We're really excited to have this group of panelists with us here today. For those of you that don't know me, I'm Ishi Shah. I'm Gen 2's Chief Commercial Officer and Head of Client Relationship Management. We've been working behind the scenes with a lot of the industry experts that we have here with us today to understand the rules better, to collaborate on, the rollout of the rules, and ultimately work with you, our clients, in terms of encompassing this into our quarterly reporting. So we're very excited to have all of you as well as the panelists here today. I'm going to hand this off to Jackie Kamitsis, who's our Global Head of Risk and Control, who is going to be moderating today's panel. Thank you, everyone.
Thank you. Can you guys hear me? Oh, okay. Ooh, I get double. All right, so my name is Jackie Kamitsis, Head of Risk and Control here at Gen 2. If our panelists could introduce themselves.
Hi, thrilled to be here. My name is Neal Prunier. I'm Senior Director of Industry Affairs at ILPA, the Institutional Limited Partners Association, and I'm helping lead the project that we're currently undertaking to update our templates to adhere to the new SEC quarterly statements rules.
Greg Hegeric, good to see everyone and good morning. I'm the Head of Compliance for North American Private Markets at Bain Capital, where I serve as the Chief Compliance Officer for 7 of our affiliate advisors. And I've been fortunate to be the spearhead lead for Bain Capital on the quarterly statement rule amongst the other private fund rules as well.
Igor, Rozenblit, partner with Iron Road Partners. We're a regulatory consulting firm. I spent 11 years at the SEC, mostly focused on private equity, starting in 2010 with the implementation of Dodd-Frank. And of course, us and our brethren are very focused on quarterly statement rule and the private fund rules in general.
Great. Good morning, everyone. I'm Bob Palmer. I'm a partner at Proskauer Rose. I also was at the SEC. I was in the enforcement division in the trial unit from 2000 to 2009. Since that time, I've been representing clients in various SEC-related matters, including private equity-related compliance, SEC exams. So it's great to be a part of this panel today. Looking forward to the conversation.
Hello, everyone. I'm Jasmine Chitrakar. I'm the Chief Accounting Officer at Madison International Realty. We are a registered investment advisors, and we invest in US and Western Europe. And I'm taking the lead at Madison International Realty to apply the quarterly statement rule.
Good morning, Marion Rosewell, Principal Gen 2. As you can see from my photo up there, I've been working there for a number of years, and it's a pleasure to be with you today.
Thanks. Thank you, everyone, for those introductions. So the SEC's objectives in crafting the rules were to increase transparency, address conflicts of interest, and improve governance. Do you think the rules have met these objectives, Igor?
So I think this is a pretty unusual rule. I mean, the SEC has a 3-pronged mission, which is to protect investors and ensure fair and orderly markets and facilitate capital formation. And so you would think all of the rules would be focused just on those issues. This particular rule was spearheaded by Gary Gensler, who's the chairman of the SEC now. And he was pretty clear that what he was focused on was, in his words, leveling the playing field and reducing fees in the industry through transparency. And we know that because he's talked about it multiple times in speeches and to the press. In terms of the private funds rule, I feel like there are components to this rule, including the quarterly reports, which are sorely needed by the industry, frankly. And from my experience at the SEC and now as a consultant, and all of you know that the fee structures are complex, that LPs deserve to understand what they're paying. And this seems like a step in the right direction. I am fairly confident in that because half of our clients now are saying that whether or not this rule gets overturned in the courts, they would comply with components of it. So they would enhance their own quarterly reports because they themselves agree that they need to provide a little bit more transparency. As to the rest of the components of the rules, I think there are certain components that don't make a lot of sense and that seem somewhat political, like the restricted activities rule, which is hard to comply with, and it's hard to see what the benefit of that particular rule are going to be. But the quarterly reporting components I happen to like.
And if I could add, so the goal right, more transparency, providing LPs to better monitor their investments. I mean, all of that will likely lead to greater disclosure, greater transparency, mitigate risk, all consistent with the goals that the Commission has put out there. The one goal that I don't think is stated directly in the release is that this also will provide a template for the SEC to identify conflicts, to investigate potential misallocation of fees, exactly the types of things that the SEC Enforcement Division has been doing, the exams also has been doing for years. So all of that, although not stated, I think is part of the underlying goal and something to keep in mind too when thinking about compliance with this rule, because this will be a whole set of disclosures to your investors that could be subject to scrutiny by the SEC. And so to be mindful that this is more than just a reporting exercise. It actually is something that, and I know folks, especially since the folks are here, are thoughtful of that approach. I do think that is an underlying goal with all the rules in the private fund advisor rules.
Yeah, and I totally agree with Bob, but I have almost the exact opposite take on this issue. And I think the examiners at the SEC do as well, which is that this, at least the quarterly statement rule, can significantly de-risk exams for everyone, because examiners will be so focused on this rule, which is very well defined, that they will almost have no time in their exams to do anything else. And because this rule is so well defined and and you're developing it, it really provides a good tool for everyone here to do testing and to ensure that the quarterly statements are right. And as long as they're right, it feels like it would take a lot of risk out of the exam process.
Yeah, and I'll agree with this. And part of our sort of approach on this from the enforcement side, from the exam side, we see it sort of from a different point of view. I always see it from the bad point of view. You see a much broader universe, but definitely all of this disclosure, the process of going through preparing the quarterly statements and the disclosures that go with it will definitely de-risk, as you say, in the exam program.
As long as you get it right.
As long as you get it right, and you are thoughtful about it, right? All these require decisions. There's discretion along the way. Going through that process and being thoughtful and documenting, I think, will be key.
Neal?
So as ILPA, let me preface by saying we did submit our first ever amicus brief in support of the SEC to try to preserve the private fund advisors rule. And that's because, as Igor highlighted, we did think that this rule affirmed the three-pronged priorities and approach for the SEC and has really strong alignment with the three priorities for ILPA, those being transparency, governance, and alignment of interest. All that being said, when we wrote the amicus brief and as we've been reviewing the private fund advisors rule, we have not tried to do a point-by-point defense because there's some elements of the rules that we agree more with, and there's some areas of the rules that we agree less with. One of the reasons we've launched the project that I've referenced before is because we want to avoid unintended consequences. And I think unintended consequences is one of the important elements when you think about the success of the private fund advisors rule and how it plays out in the industry. So one of the goals was to level the playing field and to create a higher floor for LPs as far as baseline transparency. That's great, that's a win. However, unintended consequence could be with the SEC requiring fund level reporting as the new requirement, that LPs who are accustomed to receiving LP level reporting, that could be seen as a step back. So that's where we as ILPA have to come in and think of ways to craft this project and craft the ultimate standardized approach to the quarterly statements rule of how does it need to apply the SEC requirements, whereas where there are also ILPA recommendations based off of what LPs are accustomed to and need to receive. But this is a higher floor. I was talking to some of the fellow panelists before. We estimate that roughly 50% of funds in the industry today provide the ILPA reporting template. However, in about 90% of the cases, that's only achieved from side letters. So that's very inefficient for LPs to negotiate and very timely to negotiate. So this puts it on the table for everybody. And it will create greater transparency into those partnership expenses. Only about 1/5 of those GPs providing the ILPA reporting template today actually provide line-by-line partnership expense breakout, whereas what's going to be required by the SEC will require a good amount of transparency there. So that is a win. Again, as long as we can ensure some of the unintended consequence, like LPs no longer receiving LP-level reporting, does not come into fruition.
Thank you. Greg, where do you perceive the greatest compliance risk or legal jeopardy for GPs?
Yeah, it's a great question. I appreciate Igor's perspective on de-risking the exam process, because that's an interesting view, and I tend to agree that the exams will certainly, if the rules stick, certainly focus on these particular rules. I think along the way, though, there's a lot of compliance-related risk in terms of preparing for these rules and unpacking all of them and trying to get it right. And both panelists are correct in the importance of getting it right. Now, trying to identify, determine, and evaluate what the right answer is for these particular requirements is, somewhat of a moving target. And so I think there's always risk of a process of trying to get to a good place, a reasonable place, and practical place around all these rules, while trying to navigate, what is, still some uncertainty as to the prescriptive nature of the requirements. So I think just the compliance risk of understanding it. And then there's also, a firm-wide level risk of, these are, very substantive requirements that are going to take quite a bit of time to navigate and get into place. And so there is a level of just distraction from the day-to-day responsibilities that compliance officers have and chief financial officers have as it relates to ongoing operations of the fund. Certainly this puts an onus on finance teams at organizations, particularly the quarterly statement rule, to be able to provide the requisite information. So there is a risk of competing responsibilities, competing requirements that we're all trying to manage on a day-to-day basis. And so as we move through some of the uncertainty, and we'll talk about the pending litigation, I think it's still critical to sort of evaluate these rules, to be able to be smart and intentional about how you approach implementation while not losing sight of all the other day-to-day responsibilities. And I think, like any new rules that are this substantive in nature, there can be this lost focus on the task at hand. So continue to emphasize to our teams the need to balance both.
So what Neal said was kind of interesting to me, because right now we provide a lot of expense details on our quarterly statements by LP, but because of the new quarterly statement rule, we're actually considering pulling it back and providing fund level details, and on actually quarterly statements not provide as many details as we currently have in our quarterly statement. So what Neal said, it's like, yes, we are hoping to pull it back because we know that's going to put so much pressure on our finance team. So we're trying to pull it back from LP level. It will still have anything like management fees and carried interest, but not as much details as we provide on quarterly expenses.
Thank you. Bob, can you provide us with an update regarding the litigation between the various industry groups and the SEC?
Sure. Update, not prediction. So the case is fully briefed. Oral arguments were in early February. There was reporting on that. The parties have asked for the Fifth Circuit panel to decide by the end of May. That's not necessarily guaranteed. It's up to the court. If there is a decision by May or whenever, either party or the losing party has the right to request an en banc hearing before the Fifth Circuit. Would be a hearing before the entire Fifth Circuit court. Alternatively, it could be appealed to the Supreme Court. Taking en banc or cert to the Supreme Court is, of course, discretionary, but all of this is to say that there's a fair amount of uncertainty as to the timing of any sort of final resolution. And as to the prediction, there's been various speculation out there. I'm not going to give my take. It could be a wide range of where the court lands. But all of it's to say, the timing, although there is a push to get clarity, it isn't necessarily going to be the case, since there would be a right of appeal. And when that happens, it's fairly uncertain.
For the benefit of the audience, could you please outline the circumstances under which the private fund would be in scope for the quarterly statement rule?
Sure. So it applies to registered investment advisors. The reporting regime is split between illiquid and liquid funds. A liquid fund is any private fund where investors do not have a right to request redemptions or have limited opportunities to withdraw before the fund's termination. And a liquid fund is every other private fund. There are some other in-scope determinations to make as far as reporting. The rule provides that the fund and similar pool of assets should be consolidated, or at least consideration for whether there should be consolidation. And that involves some amount of judgment as to whether consolidated reporting for a similar pool of assets would provide more meaningful disclosure to limited partners. So again, it does provide some judgment there, and interaction and engagement with the LPs is suggested as part of the release.
The focus of this panel discussion will be the quarterly statement rule. However, other rules, for example, the restricted activities rule and the preferential treatment rule, require event-driven disclosures. How do you anticipate these reporting requirements being met? And do you expect these disclosures to be incorporated into the quarterly statement? Igor?
So that one's to me. So I find the restricted activities rule particularly challenging. And it's for this reason that you said, because many of our clients, so the way the restricted activity rule works is there are 5 or 6 restricted activities. One is completely prohibited, and the others could be engaged in after some disclosure period, or in rare cases, consent. And it turns out the disclosure period for the restricted activities matches up exactly with the quarterly statements. And so it's natural, and I think the SEC expected that the quarterly statements would be used as specific disclosure for these restricted activities. The challenge is that for our clients of a certain size, and you don't have to be too big to hit this size, compliance is not involved with day-to-day allocation of expenses, which is kind of a big part of what is restricted, what is covered under the restricted activities rule. And so in order for compliance to make sure that everything is disclosed, the restricted activity has to be first identified somehow. And either through technology, where a certain kind of expense allocation sends a flag to compliance, or through training. Once that's identified, then it could be disclosed, but it's really challenging to identify every single instance of something that could be a restricted activity. And the one that would happen most often is there's a prohibition of a non-pro rata allocation of expenses between clients having to do with an investment, a prospective investment, like a broken deal expense, or an investment actually in the ground. And so that happens, and it needs to be identified, and it's nuanced because it only affects clients, and so we're working with that. The preferential treatment rule for private equity, mainly that means the sharing of side letters or material economic terms before you close, and on an annual basis, sharing preferential information with other investors in the private funds. The two things that I see some convergence on that I'll just bring up is there's question number one is the way the rule is written, it says when the fund closes, you have to provide disclosure, and then annually thereafter. And there was a question of, well, what if the fund closed before the rule went into effect? Do we have to provide disclosure annually thereafter? And I think most people are saying yes. We have some large clients that have really old funds from the 90s still, and maybe they won't provide preferential disclosure on those, but people are just thinking it's easier to provide wide disclosure. The other thing that I think is actually in the statute that people are asking is, essentially, can we structure around it? So we all know we have to provide preferential terms disclosure to all the investors in a private fund. But what if I have a fund of one running side by side with a commingled fund? Do I have to provide the preferential terms that fund of one gets to the other investors in the commingled fund? And I think the answer is no. There's actually a section in the Investment Advisors Act Section 203 that prohibits the SEC from promulgating rules that would force investment advisors to share information from client A with client B. And so the SEC was actually prohibited from forcing that to happen, and therefore the rule is written the way it is, which is investors in a private fund. So ironically, you can structure around it if you chose to do so.
Yeah, and just one thing to bear in mind, certainly disclosing sort of the subsequent disclosure of certain restricted activities can be accomplished through the quarterly statement. But it's also important to bear in mind that the different time periods for the delivery of the quarterly statement as opposed to the restricted activities subsequent disclosure. So to the extent you're talking about an event that takes place in the fourth quarter where your quarterly disclosure doesn't need to go out until like 90 days after, the restricted activities rules has a shorter fuse, a 45-day notice from the activity taking place that quarter. So bear in mind that it certainly can be done through a single document. It may not always work. At least as I read the rule, the restricted activities disclosure is sort of a hard and fast 45 days. There is some suggestion that if the quarterly report can't be filed within the time period, how would you deal with that? So just keep in mind the different time periods. I think we'll talk later also. The time periods don't always line up with the financial statement audit reports, which again is a little incongruous to the extent it's similar information or likely something you might do in a single document if you could. But each of these rules have slightly different deadlines that just you need to pay attention to when considering that.
And we do have smaller clients that if they used the quarterly statements to disclose their restricted activities, because of the timing issues, they see that as creating cash flow issues for them because it would take just so long to allocate these costs. But yeah, to your point, it's not a one-to-one.
Yeah.
And we could do an hour. We won't, but we could do an hour on each restricted activities, on preferential treatment. I'll hone in on preferential treatment for a moment because I think this is a perfect example of what I was referring to before as far as unintended consequences. So Igor highlighted how preferential treatment is structured. It has three different ways it's being structured. One is related to data that's provided, one's related to redemptions, and one's related to side letters and what's agreed to in an LPA. As ILPA, we push to have private equity carved out from this rule because our LPs are so reliant upon side letters to get some of their state-specific requirements into the books and into the legal sphere. And then we also really wanted to avoid unintended consequences of data no longer being provided. So the example of this would be co-investments. There's an open question now of, are you allowed to provide co-investors with more in-depth information than other investors in the fund? Or members of the LPAC, are you allowed to provide them with more in-depth information relative to other members of the funds? But related to the data more holistically, it's related to holdings and exposure information and portfolio company information. So we push the SEC, as I mentioned, to not include this. The SEC even includes commentary that says, generally speaking, because there's no redemptions in private equity, they don't believe that this rule applies to private equity. That's great. The only challenge is on the page prior to that in the commentary, the specific example that SEC gives of what would represent a breach of this is a GP providing one LP in a private equity fund ESG specific data and not providing that to other LPs. So then that creates an open question about, well, does this apply to LPs? And ESG is already a sensitive enough topic, so it was a little bit discouraging to see that. So we're also trying to navigate this path to avoid some of the unintended consequences, not so much for how it directly would show up in quarterly statements, but for the larger experience of LP-GP connections to prevent a lower ceiling being introduced as part of this higher floor being introduced.
Yeah, I mean, to Neal's point, for us, we're kind of ignoring that ESG statement as kind of, a throw-in someone put into the release that made someone happy to vote for the rule. But the one thing we're struggling with, and I don't know if Neal has an answer to this, is whether or not there could be a foreseeable material negative impact if funds are traded on the secondary market. We just don't have an answer for it. I don't know if ILPA has an answer for it.
Not yet, but we will.
Not yet. Okay.
For us, we're focused on process and communication to start around all of this, particularly, all the rules, but preferential treatment I'll take specifically. With this rule coming into effect in September, with fund closings, anticipated fund closings, uncertain as to the timeframe, communicating the impact of this to our business has been critical, so that it's eyes wide open as to what we'll need to disclose and when we'll need to disclose it. There's a real operational component to this, right, as part of the pref terms, which is the need to disclose all material economic terms to all investors prior to closing. And so, as you can imagine, as you're negotiating side letters up until the last minute, as you're negotiating terms with other LPs, the timing of all that as it relates to a fund closing can be really tight. And so working with fund counsel on a plan has been a really key component of our project around all of this, so that we are at least planning for, notwithstanding any litigation here and how that unfolds, that come September and any closings post-September, we're going to need to disclose this. And so starting to identify what we're going to need to disclose, how we're going to disclose it, and ensuring our business is completely on board with that process has been, really number one starting point for us. And so, there's a lot still to navigate around pref terms, around restricted activities, but the more communication and messaging with the business so that they're brought along has been really important for us.
Thank you. Neal, what guidance will ILPA be providing with respect to the quarterly statement regarding requirements both in the context of the fund level reporting mandated by the SEC and then ILPA's quarterly statement?
Sure, and to take one quick step back and tie it to the litigation point, what comes out of litigation could be anything ranging from vacating a specific element of the larger rule package, vacating the entire rule package, or something all the way on the other side that would be essentially equivalent to repealing Dodd-Frank. That's why ILPA submitted an amicus brief, because we really want to prevent that other side from happening, because we do think there's benefits of Dodd-Frank and what it's introduced to the industry. I highlight that, though, just because we are working on a project, the ILPA Quarterly Reporting Standards Initiative, to try to standardize the adoption of the quarterly statements rule and do this in an organized fashion to help answer all the questions that are out there based off of the translation of 2-3 pages specific rule language, 100 pages of commentary in the rule itself. Within that, our plan is to keep moving forward, even if the rule is vacated. We would likely make some tweaks to the timelines, to the implementation date, but holistically, we would continue to push it forward because we do view this as the natural next evolution of ILPA reporting standards, especially when you think about getting much more information on a quarterly basis related to partnership expenses. So it warms my heart to hear that 50% of Igor's clients are interested in pushing this forward, because that's what we want to do. So with the ILPA Quarterly Reporting Standards Initiative, and as a very quick aside, we've got Peter and Maren, who have been absolutely tremendous members of our working group. We've got 2 different working groups and a steering committee comprised of LPs, GPs, fund admins, and some different consultants. And Maren and Peter have been leading the charge from Gen 2 and being absolute tremendous additions to the group. But we're trying to identify what does the new template look like and what are the corresponding guidance and instructions that need to be provided alongside it to make sure adoption can happen in the best way possible. We also are purposely working with fund administrators and we'll be coordinating directly with different tech providers, because we want to try to ensure that this can be done in as automated as a fashion as possible, with clarity and instruction, so that if the current ILPA template today that has 9 partnership expenses, including one that says other, well, we can't do that anymore. You can't use other. So we know we're going to need to have 20, 30 partnership expenses, and so want that to be as standardized as possible across the industry. So any template that we put out will have guidance as far as what goes into each bucket, what shouldn't be included in each bucket, because we know there's going to be a big ask and a big effort in the industry, given that the performance component needs to go back to inception, to kind of rebook some of the data and map over data into this new format. Our goal with this project is to run forward with the working groups and to have materials ready for a public comment period in June, with the idea of being able to run a 5-week public comment period, which you all are more than welcome to participate in. We would love it. And then have everything finalized by July so that it can be out into the industry to give everybody time on the back end to do some of that data mapping, to do some of the necessary IT work between July and 1Q 2025, so 3/31, which is the first required reporting period under the rule. If you're interested in getting involved even prior to the comment period, we are also launching what we're calling satellite groups. There's been an outpouring of interest, and we couldn't have everybody sit on the working groups themselves. But if you're interested in getting involved as far as providing us information, providing us input prior to the comment period, or just staying in the loop of emails and updates, we have the ability for you to do that on the ILPA website. If you go to our homepage right now, ilpa.org, it's on the front carousel. It's the second or third item that pops up. It's also in our principles section. But we have a form that you can fill out and indicate if you want to just be kept informed of progress or if you want to participate in one of our GP satellite groups, because we do want to make sure that transparency and communication is a real point of emphasis of this project, given, as the group has talked about, how big of a change this represents and how much time this will be for individuals to factor in how to apply this within their individual organization.
Neal, your check's in the post. Actually, we're on camera, so cut that. Having participated or being an active participant on a couple of these working groups, it's pretty invaluable given what you were saying. I mean, the rule itself is only a couple of pages, and then you've got this 100-odd pages of narrative, and within that narrative, there are certain contradictions or certain things that don't necessarily lack clarity. So, as we say, it's valuable participating, listening to other people speak around and trying to interpret the rule and come. We don't have much time to implement, to try and shortcut the flapping around and the discussion just to get to a salient point and then be able to move on, I think is invaluable. So,
and one of the biggest areas to highlight as far as like where there's discrepancies are gaps with what's in the rule or in the commentary itself. What the SEC outlines as part of the performance metrics is that you also have to provide a statement of contributions and distributions. We've been referring to it as cash flow. And what the SEC has identified is that for each cash flow that takes place, you need to determine and show whether it is an inflow or an outflow. Well, they also indicate that LPs should be able to recalculate their performance based off of this cash flow information. So simply having inflow, outflow information isn't enough to do that recalculation properly when you think about impact of fees and expenses, when you think about things like recallable capital and how that needs to be applied in the numerator and denominator of the MOIC calculation. So we're trying to identify, well, this is what the SEC has said, but this is what is actually needed to do in full what the SEC is requesting. And we don't want to have 30 transaction types, but can we land on 6, 7, 8 transaction types, maybe 10, 15, that get the necessary granularity to actually achieve that goal of calculation, recalculation from LPs who receive this cash flows information.
Thank you. The rule requires the quarterly statement to be delivered within 45 days of quarter 1 through quarter 3, or 90 days of quarter end for quarter 4. For fund of funds, there are 75 and 120 days respectively. For those funds that historically issued investor reporting outside these timeframes, but in accordance with the LPAs, many GPs are contemplating an accelerated financial statement reporting timeline to facilitate issuance along with the quarterly statement. Jasmine, how are firms preparing for the quarterly statement rule?
So, like I said before, actually before I say anything, I was supposed to add the disclaimer that this is my point of view and not Madison's point of view. So, like I said before, on the quarterly statements right now, we already provide a lot of expense details. So we're kind of set in that we have a consistent level of expense categorizations already included. So we apply that consistently across all of our funds. The one thing that Neal also pointed out, there's a catch-all category called other income. It's not a large amount, but we still need to figure out how to categorize that properly. A lot of our funds already report on 45 and 90 days deadline, but we have a couple of SMAs with that we have negotiated longer reporting deadline, mainly to ensure that the valuations can be completed at the portfolio level by our sponsor, where Madison doesn't have a lot of control. So in that sense, our portfolio management team, which produces valuations for us, I think they're going to have to potentially produce fair values without complete information. And we have negotiated deadlines for our sponsors that we might have to reopen the docs just to get the appropriate information. Some of these SMAs also require appraisals, so that's going to put a lot of pressure. So these are all the items that we're still discussing. But the one thing I also wanted to talk about is that on the statement of cash flows, right, even if you provide it at the fund level, it's not like an LP is going to be able to take pro rata for all of those categories and apply it directly to their experience, because some of these expenses are just not pro rata to them. So I'm not sure what SEC is trying to accomplish with that piece. Then once you add the with and without the impact of subscription facility, it's just a lot of details that you're going to have to provide on the quarterly statements. So basically quarterly statements is going to be pages and pages long, and then on top of it, you have to add disclosures, which is, we don't know how big it's going to be. So we're considering all of those factors as we consider the quarterly statement.
Yeah, and I want to circle back to some specifics, but take a step back in terms of quarterly statement rule and all of this, which is simply, this can feel very daunting, particularly in the context of the amount of rulemaking that has taken place by the SEC. I mean, it feels overwhelming for compliance and finance professionals. I lead every message to our team with, don't shoot the messenger, but SEC just adopted X, Y, and Z. So whether it's Form PF or it's new custody rules coming, or the plethora of rulemaking that is taking place. So it can feel overwhelming. And so I think a critical part of just this process and starting off is coming from a positive perspective, both for the business and for our teams within our compliance and broader legal teams, which is, let's make this something positive, right? It doesn't feel that way, but let's try and attack this like it's going to be something really important, whether it's for ILPA or LPs, that this is a really important endeavor and we can learn a lot from this process. And so just starting from a positive perspective on the overall rules, and it just has created a tone of approach that is less defensive, which I think is important for the team. And then secondly, to remind our compliance team and others who are engaged in this process, like, this is a really good learning opportunity for individuals, because you get the opportunity to dig into particular rules, into the businesses, to understand and unpack what's required and learn along the way. And so, again, we're creating an atmosphere, hopefully, of a positive approach to all this, while having to navigate, again, what is, feels like second and third jobs as it relates to all the rules. So just from an approach perspective and a mindset, like, that's been really critical, and foundational as we've leaned into this with our teams. In terms of particulars and specifics, there's a lot to digest. I mean, we try and approach this from a practical perspective. Let's get what they're asking right. Let's just start there. Right? Let's just start with understanding what they're asking for, identifying the questions that we're not sure of, talking to our legal counsel and consultants to continue to navigate those questions. But let's just start to get what they're asking right and start to identify the data sets and what they're looking for as a starting place, right? There's a lot of other things in the rules about expectations or this or that, feels like a lot at once, but rather focus on what are the core things they're asking for in the rules and not getting distracted with everything else, at least as a starting place. And so we've been approaching that, like, let's just understand what they're asking for. Let's document it, let's digest it, let's figure out where are the data sources, who are the resources we need to get this all done, we still have a year, right? We still have a year in terms of the date this quarterly statement rule goes into effect. So it feels like a long time, but it's not. That's been the message. We have time, but we don't. So let's just be intentional about all of this. And so it's been very programmatic. We've treated this somewhat like we would treat an SEC exam, which is let's mobilize around the rule, let's get a team involved, and let's just work with pace and intentionality without causing sort of too much stress on our finance teams who are a big part of this, right? Because we do have some time. And so I think we are feeling better about the requirements because we are being mindful about how we're approaching it. And so there are particulars, right, that we have to get into, like the level of expense detail. What's the right level? What are the right expense categories? Can't use other. We still have to determine all of that and make sense of all of it. And we have to coalesce across, a platform that has, multiple hundreds of funds and 12 registered investment advisors. So it's a real challenge. Working with Gen 2 to help us in that process has been critical. Working with peers, I'm always willing to talk to other peers. That's really something I value as part of these sessions and others as to what you're seeing, what you're thinking. Like all that feedback is really important to us as we navigate it. So we don't have all the answers for sure, but it is really identifying what the questions are and keeping track of those and addressing as you move forward in the project.
Yeah, if we look at this as far as what is the intended benefit, the intended benefit is to try to create more transparency for LPs. So in one regard, I can see the pros of pushing for 45 days. On the other hand, if 45 days just fundamentally is not possible, it then becomes counterproductive because as GPs, you have to provide something at that time that is estimated as of the prior quarter end or prior month end, likely prior quarter end. And then you would likely have to follow up 15 to 20 days later with a actual quarter end because LPs aren't going to want to wait till the next SEC mandated period. So we had pushed for longer than 45 days. As part of it, recognizing that the industry wasn't there. So all that being said, recognize that it puts GPs in a difficult position if you're not currently operating within that 45-day window. Without understanding all the facts and circumstances, I think the LP preference would be to have those GPs shift to being able to report within the 45-day window. But we do recognize that creates challenges. And again, this is another area of potential unintended consequences and potential blind spots. So the rule outlines the reporting for direct funds and fund of funds, but there's not a further distinction for fund of funds, which isn't a huge part of the market, but you would typically double what you do for fund of funds for fund of funds. And that's not incorporated within the rules. So there are some of these different pieces that we're also simultaneously to running this project, trying to surface as many questions that we can to provide to the SEC. Because of the litigation, the SEC can't answer anything right now, and it's going to take a little bit of time for them to put out any interpretive guidance, but they've asked to have all the questions sent to them on a regular basis so that as soon as they do get the green light to be able to respond based off of the status of the litigation, that they already have all these questions in-house and have started to work on them. So there are some of these types of things that we're trying to address. And that's another area where if you as GPs have identified different questions, we want to try to surface as many of those as possible so that we can submit them to the SEC so that once they are available and able to respond, they have everything in their back pocket and can get a response out as soon as possible.
Thank you. Other than the quarterly statement rule requiring quarter-to-date information and additional granularity versus the financial statements requiring year-to-date information, do you expect that the basis of accounting will remain the same between the two reports?
Yeah, that's an interesting question, Jackie. Before I get there, just following on from the prior conversation, I mean, just looking at some things we have to build or implement in order to meet the reporting requirements. If you're looking at, say, your covered portfolio investments, ensuring you've got all the requisite related persons, compensation information, that could be a whole new data collection process. Then, you're looking at what is this reporting entity under the quarterly statement rule versus the financial statements or PCAPs that people have been receiving. So you're looking at, okay, The SEC said consolidation where meaningful. Is that different to how you're thinking about financial reporting? As I mentioned earlier, the definition of a covered portfolio investment and those requirements to report, and they've included within that holding entities. So at each level, what are your disclosure requirements around that, and how are you collecting that information? So I know we've been discussing with certain of our clients around that. With respect to this specific question and whether we have a different accounting basis, I know we've been privy to certain discussions. What does paid or allocated mean, for example? And some people are going and debating whether that means cash basis as opposed to accrual basis. Now, we think accrual basis is the appropriate basis, but nevertheless, it just shows there's a little bit of confusion in the marketplace. With respect to then allocated, I mean, that's a pro rata allocation. It's your fund's allocation of a particular expense or particular compensation, and that could potentially differ when you're thinking about financial reporting and you don't have a wholly owned subsidiary, and therefore you're dealing with minority interests. So again, this could be a different reporting basis, adds complexity, potentially adds confusion for the investors. They're receiving this statement, and that's probably going to warrant, certainly in the early stages of this rule, having resources to be able to deal with those investor inquiries.
And I'm just looking at our questions here. It's not to mention that there's also some difference between performance reporting for the purposes of the marketing rule and performance reporting for the purposes of the quarterly statements. I think they could be rectified, but the two rules treat performance slightly differently. So lots to consider.
For us, we don't have any fees at the portfolio investments level, so we don't have that kind of granularity. But we do earn some type of fees in the holding vehicles that are not consolidated. So as Maren pointed out, we are going to have some differences between what we report on our financial statements as expenses versus in the quarterly statement. Currently, we already disclose all types of fees and expenses, fees and reimbursements earned by the manager on our annual disclosures and the financial statements as well as the management report. But because it's in a disclosure and not exactly in a tabular format, I don't think the variances are as clear to our LPs. But after we start putting in a tabular format as required by the quarterly statement rule, I'm assuming that there will be some type of investor inquiries asking why there's a difference between that. Also, expenses could be capitalized, and on the financial statements, it's not going to be showing in the income statement. So those are some of the things we're considering as we prepare for the rule.
And you also have certain expense recharges that now got to be reclassified as compensation. But looking at the related persons and the various compensation and fees at the different levels is going to be interesting.
That's exactly what I was saying. Like we have holding vehicles where we do have those recharges of expenses, and those we disclose currently in the finance statements. It's one line item that appears, but we're going to have to break it out between various categories for sure.
And Jasmine, there's one thing we're doing at the moment which I'm not particularly enjoying, but it's trying to cross-reference all these various expenses to the LPAs. If you look at the way they're described, particularly under the partnership expenses, where you typically get a long litany of different types of expenses, trying to do those cross-references, marry up the chart of accounts, those definitions can be an interesting exercise too.
Yes, for sure. We are most likely going to engage our consultants and counsel for that piece, because we have a lot of funds that we're managing. So I don't think with our small finance team we're going to be able to do that. And it's also going to be a combined effort between our administrators as well as us. So I think it's going to be a combined effort.
All right, so the rule requires prominent disclosure regarding a manner in which all expenses, payments, allocations, rebates, waivers, and offsets are calculated, and includes cross-references to the sections of the private fund's organizational offering documents set forth in applicable calculation methodology. Maren, what difficulties do you anticipate in meeting this? I know you
I think I touched upon it just now, but look, obviously going through the LPAs and then trying to match up the chart of accounts, and we don't have necessarily one standard chart of accounts. It's customized for each of our clients, but also there's not one standard LPA and definitions around that. So trying to come up and identify these permitted expenses and then describe either the allocation or calculation methodology in a clearly understandable terms, because plain English is one of the requirements around this, is going to be an interesting exercise. But going to Jasmine's point as well, this is going to be an extremely voluminous document, potentially not only because of these cross-references and descriptions and disclosures, but also no de minimis, no aggregation, so it's going to be quite a lengthy doc, and how meaningful that's going to be to our investors is going to be interesting too.
Yeah. So do you anticipate that the LPs will have to be rewritten to identify permitted expenses more specifically and describe how they're to be calculated, or are there going to be larger expenses, higher fees?
For us, for our clients, at some point, LPAs start looking the same client by client, and there are not that many provisions delineating what expenses can be charged and how fees are calculated. So I don't know if they would have to be rewritten. I think the second part of the question is, would they be more detailed or less? I can't see them being any less detailed, because I think it's pretty clear now that the SEC would require specific disclosure of all expenses. They might be more consolidated, although we haven't really seen much headaches around linking provisions back to the LPAs. Where things get complicated is the allocation methodologies, which are usually not disclosed in the LPAs, and the bigger you get, the more complicated they get. And we have clients with dozens of different allocation methodologies that essentially live as finance policies. Those may need to be consolidated and explained a little bit better for the purposes of general consumption. And this is where kind of what Bob was saying earlier, where some of the risk lies. You would need to make sure that whatever you provide to your investors in these quarterly statements matches up with what you're actually doing. And we do a lot of expense testing. That's kind of a big part of what we do. And every quarter there's a new expense, and every quarter there's some discussion about what exactly this expense is and how to allocate it. And so there's a lot of change in that area too. So that could be an error-prone situation.
Yeah, and I'll sort of give some of my perspective on this, thinking about, to Igor's point, the quarterly statements are going to have to track how you sort of define partnership expenses, for example, in the LPA, and sort of thinking about the terms of the LPA and trying to match that to the quarterly statement, I think is important. I also think it's important to look at, most definitions in an LPA will say partnership expenses shall include, all expenses related to the operation of the partnership, including but not limited to, and then a laundry list of things. I don't believe it's correct to view that laundry list in the LPA must precisely track the expense categories that you're being obligated now to report on the quarterly statements, because the SEC now expects more granular detail that you're just not going to see in an LPA. But being able to match that a category, subcategory of expenses tracks to your LPA language is going to be key. I would also sort of think going forward, I don't know that you necessarily have to keep expanding that laundry list in the LPA of the definition of partnership expenses, because we've seen in the past that type of enhanced disclosure sometimes trips you up in the exam and possibly enforcement when they see, wait a minute, you've got a list of 8 different categories of partnership expenses, and you're saying in the next fund you've got 12 different expenses, and it really is just clarification of what is and is not a partnership expense. I would hope that, to Igor's point at the start, that by providing this enhanced disclosure with the detailed expense breakdowns, you do deliver the risk that you won't get second-guessed maybe by an examiner, like, why is this expense category here not listed in your LPA? Because I would think that's an unrealistic expectation of the staff, and I hope that they would be more comfortable with the greater disclosure that's going to be required, because again, I think providing such a detailed list in LPA just doesn't seem to make sense from my perspective, and knowing how these provisions have been written in the past.
Neal?
Yeah, we've heard from some law firms that going forward, they're planning on updating the LPAs to provide greater connection to some of the things in the quarterly statements and the required linkage. I don't think it should require a repapering of LPA, of current LPAs for this purpose. I think it adds realistically an additional operational complexity as far as GPs being able to understand and provide to their fund administrator or do it as part of their own reporting what section of the LPA is this found in. That's, typically sections are the same from external counsel to external counsel, but double checking that and verifying that is just an example of an additional operational challenge and data point that will be required to push this forward.
My sense is that it generally maps to, there's nuance for sure, but initial review of the work we've done, it generally maps to the categories of expenses, the LPAs, at least that you can point to and reference. I think to Bob's point in terms of clarification, you try and be mindful of that as it relates to the LPAs, but the initial reaction to this is that it generally maps to the category set forth in most expense provisions. There's certainly, as we dig into further line items, there could be clarification required, but I think generally maps. And, my other gut reaction is that there's not 100 expense line items. It's in the 25. I'm throwing out numbers as we try and navigate this, but I don't think it's 100. It doesn't feel like that, at least the perspective of looking at all the expense details over the last several months for all of our funds and unpacking all of that. I think there's a perspective on where I think the general right number is in terms of expense detail in line items that get consolidated at the right level that is transparent and maps to our LPAs at the appropriate approach. So we'll see how this all plays out, certainly as we continue to do work, but initial reaction to that.
For liquid funds, the rule requires inception to date performance to be calculated both net and gross on an unlevered and levered basis. Jasmine, how challenging do you expect it will be to calculate gross net unlevered performance, particularly with respect to older funds?
So for us right now, we present gross returns without the impact of any type of facility expenses. So we have that, and for the net, because of the marketing rule, we do both with and without the impact of subscription facility. Because we already do that, we do have, even for historical funds, the credit facility details like borrowings, payments, any type of expenses associated with the credit facility. We have that kind of detail. What we don't have is that we have, it's in an Excel. We're going to have to assume that certain borrowing activity was related to expenses and management fees. We don't have that kind of detail right now. So I think this is going to be one of the most challenging aspects of the guidance. So we have talked about potentially applying a ratio, because we do know what the spread is, potentially applying a ratio, but we haven't really figured out how we're going to approach this. And again, I know it's not listed here, that was not a question, but we're also going to have to figure out how to allocate between realized and unrealized investments, because that's also part of the guidance. So this is something I think we're going to have to consult with our peers, talk to our consultants, advisors, and figure out. I think we're kind of waiting on the final guidance from SEC before we really approach this, but this is, I think this is going to be one of the more challenging as far as the performance returns goes for Madison.
Yeah, again, unfortunately, I have to go into our CFO's offices and be like, another calculation that we're going to have to get done here between this and the marketing rule and all the components to calculating net gross returns at a deal level, now unlevered and levered returns. It's definitely work that has to be done. And I think Igor mentioned it, but just trying to ascertain the differences between calculations and the quarterly statement rule versus the marketing rule. There are some certainly mechanical items that we're going to have to explore. So there'll be work involved in it. Generally, we have the data to do it. So not concerned that it's that unattainable in a reasonable manner, but it will certainly require some input, some assumptions likely to to get to the right place. So it's an area that is, we've been highly focused on expenses as it relates to the quarterly statement. I think the performance components of it are next on the list to navigate. Not that I have forgotten about it, but it's been, we calculate returns and have pretty thorough process. We now need to really dig into probably the particulars that need to get identified and assumptions along the way.
I think this is another great example of where is this a win and where there are unintended consequences or just some challenges we have to work through. So on the win side, ILPA put out guidance on subscription lines of credit in 2017 and 2020, both of which called for with and without. That was not really adopted. So LPs do look forward to receiving with and without the impact of subline performance. As far as the challenge, Jasmine mentioned the levered and unlevered. Well, that's gross, levered and unlevered for valid reasons, and they specify why it's not net. But the challenge is they also want that with and without the impact of subline, which doesn't necessarily make sense because that's a fund level credit facility versus looking at particular portfolio companies and what's been realized, what's unrealized. So that's a challenge that we're going to need to sort through to figure out how to apply it correctly to create a standardized approach that's going to be meaningful and impactful for LPs.
Well, one thing I learned from the marketing rule is the SEC could be incredibly flexible with how some of these things are calculated. I think one of the questions is, well, what happens if you don't have your data ready to report performance? And actually the release discusses that, and it says that using previous period is okay. And the other thing the SEC tends to be flexible about is if there is a lack of standardization in the industry, I don't think they're looking for everyone to do everything the same way. As long as your method is clear and disclosed to investors, I think they think that would be okay. And we'll see. Some of the, I think Neal brought it up first, which is that right now they're not publishing FAQ answers. I think the answers to the FAQ are highly dependent on who is sitting in the seat of general counsel in the Division of Investment Management. And so the answer you get today might not be exactly what you want. The answer you get tomorrow might be quite different. And so we'll see what kind of guidance is published. But I think, again, maybe I've spent too long at the SEC. I tend to think they end up in the rational place and do the right thing. But I understand some of these things aren't clear.
Yeah, and I think, look, it definitely seems to be the one issue that is causing the most heartburn is advisors think about how they're going to comply and start to focus on how they can currently comply with the marketing rule. I think at the end of the day, the guidance, to Igor's point, is that as long as you're transparent and disclose any assumptions to the extent you don't have the data to do the actual calculation, that would seem to be something that should satisfy the staff. And I think also to the point that this is going to be a larger problem, if you will, but a challenge for all advisors. And I don't think not being able to have all the data and have to use assumptions is going to place you in some outlier position. I just think it's a reality that could be addressed with further guidance, assuming the litigation gets resolved. But definitely, if you have to use assumptions, disclosing exactly what you're doing, I think is where people are going to end up landing on that.
To the extent that detailed records are not readily available to perform these calcs, how do you think the SEC will react to the use of estimates, such as for proportion of line of credit drawdowns attributable to expenses? We touched on it a little bit.
Yeah, I think as Igor just said, hopefully the SEC will be flexible to that. But we recognize that's one of the reasons why we want to try to have the project finished up in July, because there will need to be, if you do have access to that data, a good amount of data remapping work that goes into to kind of recalculate that and develop what the synthetic subscription line call would have looked like, or what the synthetic capital call would have looked like in place of the subscription line.
can I bring up something that worries me about that? What worries me about that is that nothing to do with the private fund advisor rule, but with the marketing rule, where you're required to have substantiation for material facts. And if you're reporting performance and it turns out you don't really have the data to back up the performance, that becomes a really big problem because obviously performance is very important, especially early performance, which influences IRR a lot, is really important. And so I'm just trying to think back anecdotally. I guess once in a while a client of ours has mentioned, well, we don't have the data. Not a lot of our clients have said that, but if you don't have the data and you're reporting performance, that really causes anxiety for me.
I think it's possible, though, if you're having transition from an in-house to outsource model, from outsource to outsource, I mean, you might not always carry over the line of credit drawdown history. I mean, you would do on the investment or investor side, but you know, you might just be pulling over balances, and that's where it could be an issue.
Yeah. I mean, you know the details much better than I do. I'm just like concerned with examiners discovering that a lot of fund managers don't have data, and then that becoming kind of a bigger problem.
And you don't think this can be resolved by basically disclosing that you're making an assumption and it's not solved by disclosures?
You can work with your counsel like Bob, and you can call your early performance hypothetical, which is performance not actually achieved, but then you'll have to have a discussion with all the great ILPA members about why it is exactly you're calling your early performance hypothetical performance when for years you've been telling them it's your actual performance. It's just, I'm getting a elevated heartbeat just thinking about it. Okay.
If I could add, though, I do think assumptions are based on data. You know, like any number of estimates, it's sort of based on available facts and information that you have. And so I think there's varying degrees where, you know, you could have disclosure that could be supported by existing data, which may also include some assumptions. But I think there's probably, you know, a gradation of where
as there
something
always is, yes.
Yeah. And look, I think, you know, there hopefully is more guidance. You're sort of stuck with what you have and make the best of what you have. But I would look differently to an estimate that's really might be based on historical trends or some other data points that you could establish that this is more than just sort of a, you know, made up number or whatever you want to call it. But a lot to be decided, I suppose.
Yep. And we've been talking about this at a fund level, right? So the question is also from an ILPA perspective, having all of that data now at the investor level will also be the challenge, right? So any points maybe, Mary, you want to give on us and where we are in terms of the project? I think that would be helpful for this group.
Yeah, look, I mean, a number of the performance calcs are already inherent within our technology, in particular sensor. I know Peter's sitting over there, and he's eager to talk a little bit about that. But yeah, look, I mean, we've got the models or the workings calculated automatically within that sensor application. Obviously, data is going to be key, so going back and look at the quality of the historical information in order to get the right output. But yeah, I mean, obviously you can automate it, but again, data quality key. So.
Thank you. So how broadly can related persons be interpreted, and consequently, how far-reaching do you anticipate the disclosure requirement to be, Bob?
Yeah, well, I mean, related persons is defined. It's sort of a term folks are used to dealing with. It would include all persons directly or indirectly controlling or controlled by the advisor. I think when thinking about how that gets defined, I think in the first instance, you know, when you think of the fund table, it's important to look at, you know, it's talking about compensation paid by the advisor to the related person. So if the compensation is paid by the advisor to, say, a sub-advisor related person, I don't know that that's covered by what's contemplated in the fund table. When you get to fees and expenses, though, if it is payment to a related party for services, I think the guidance is that in that case, that payment if it could be interpreted between compensation or fee and expense, it should be put in the compensation bucket. But I think those are sort of the areas where I see the related party definition sort of being broad enough to require judgment as to what bucket it needs to go in the fund table, or is it just a fee and expense of the fund sort of disclosure.
Yeah, and I think the release discusses the fact that related persons are persons that are involved in the advisory business of the manager. And so, for instance, if you own Qdobo, you don't have to report every time you go and order a burrito from Qdobo. It's only related to investment advisory services. Where it gets complicated is, again, for the larger managers, which have portfolio companies in their funds that provide services or that provide some sort of support to their investment advisory function, or they have related parties that one would argue are part of the investment advisory function or not. And so that's kind of where the lines have to be drawn. But I think that's when the rule first came out, there was a big panic because the definition in the rule of related persons is really, really broad, but then the release talks about it's part of investment advice. If it's not related to investment advice, you don't really have to worry about it.
Thank you. What mechanisms do you anticipate putting in place to collect the additional information regarding compensation detail that you'll require from your portfolio companies?
So luckily for us, we don't earn fees at portfolio companies, but as Maren was alluding earlier, we do recharge some of the expenses to our holding vehicles, and we already disclose that type of information. So we are hoping that we can standardize chart of accounts so that this is not, right now it's very manual process. We have to ask our administrators at the holding vehicles, which is not necessarily the same administrator as the fund level. So this is, right now, it's a very manual process, but we're hoping to standardize chart of accounts and have that information readily available to us. And we already disclose based on accruals and not paid. So I think we're on the right path as far as this type of disclosure is concerned.
Yeah, we generally have compensation from portfolio companies readily available. There are certainly nuances. Continue to be mindful of compensation paid to board members from companies that gets pulled into this compensation component, whether it's equity or cash compensation. So depending on timing of that, nature of payments, we'll have to be mindful of. And then I think, more broadly, compensation as defined under the rule, whether it's internal chargebacks to either your funds or your companies that will be deemed to be compensation to the advisor under the rule, that perhaps is a nuance that needs to be thought of, whether it's direct employees that may get allocated or vehicles that perhaps support structures or investments that could be deemed to be compensation. So thinking more broadly beyond the traditional compensation that portfolio companies may pay and consider all types of compensation the SEC would view for this purpose.
Thank you.
And one of the other big adjustments related to this rule is you think about the portfolio companies and the portfolio investment table portion of the rule is that this is requiring a portfolio company by portfolio company view. So not rolled up across all portfolio companies into one or several line items, but being able to capture these specific line items across each portfolio company. And if you're thinking then across private credit, that's across each loan or across real estate, across each property. So there is going to be much more detail that's required drilling down into portfolio company by portfolio company information.
Thank you. Although we focused on the quarterly statement rule, are there any other legal matters that you want to bring to the attention of this group? Igor, Bob.
I think the next two rules that may go into effect is the outsourcing rule, which is a rule requiring you to do diligence on some large number of vendors that you use annually, which is a big lift, and then the dreaded safeguarding former custody rule, which has a lot of provisions and a lot of accounting that needs to be done, at least in the proposed rule that heretofore was not required. And it's hard to see where all the resources are going to come from to implement those rules, particularly the outsourcing rule, which is a whole compliance process that is new for many. I think some of the larger firms already renew their due diligence, but not every year. And then, again, the safeguarding rule, which requires things like CPA verification of every single asset transfer, which is, it's quite a endeavor for the amount of transactions that are done every day.
Now you're getting my heart rate elevated.
Yeah. We should all go get accounting degrees. I'm going back to school.
I'll leave it at that. I mean, there's obviously a lot on everyone's plate and more rulemaking down the pike and a lot yet to be determined, but I think we've covered quite a bit today.
Yeah, absolutely. With that, as Ishi has reminded me, thank you all for joining this panel. Michelle sent out in the, I guess on all the decks here, that we have a specific email address. If you guys have any questions, follow-up questions that you want to handle, we can take those in and then respond accordingly. So thank you all for your time. Enjoy the rest of your day. Thank you all.